go. Here we are. Give it a couple of minutes just to see everyone join. Thank you all for joining today. We're just waiting for, whilst the number goes up, people are joining every minute. So we'll just give it a couple of minutes before we start. Chance for everyone to grab their sandwich. Excellent. There we are. Well, I'll get going and then people can join in. So welcome everyone today for the second lunchtime PLA session organised by the Southern Region team. My name's Nicola Davis. I'm a property litigator at Paris Smith and work in the Southampton and Winchester region. Today's talk is going to be by Simon Williams, who is a barrister and mediator from Radcliffe Chambers. He'll be giving a 30-minute talk on determined boundary applications and the pros and cons for doing those, followed by a 15-minute question and answer session afterwards. So please put all your questions whilst he's talking in the chat box below, and he will do his best to answer as many as he can in the 15 minutes. We have got a really good turnout today. We've got about 260 people signed up, and at the moment the numbers are just going up and up. We've got over 100 people joining us so far. So Simon, good luck with answering all those questions. And over to you, Simon. Thank you for joining us today and giving us this talk.
Well, Nicola, thanks very much for inviting me. It's always a pleasure to be able to share one's experiences, and particularly at the moment when we're all scattered around the countryside and not meeting as we normally do at a seminar, when we then have the opportunity to chat afterwards and have a glass of wine and so forth. But hopefully you're all sitting comfortably wherever you are, having your sandwiches or sitting in the garden or whatever you're doing. I'm not going to hopefully make this too heavy, but I thought I would share with you some observations from a recent experience I've had of boundary determination, case that went to the upper tribunal, Woodhead and Witt, last year, which I thought was instructive in many ways. And so let's see whether you agree that this is of any interest. So I've got a few slides which I will hope to share with you. So if you'll just bear with me for a moment, I'll try and get those up on the screen, and hopefully you can now see those, and we'll kick off. So a minute. So the boundary determination jurisdiction, as you will all be aware, is contained first of all in section 60 of the Land Registration Act 2002. And I've highlighted the essential parts. You'll be aware that there's quite a bit more to it, but I thought I'd just strip it down to the basic elements for today's purposes, so that we can focus on the basic jurisdiction. So as you will all know, the boundary of a registered estate is a general boundary, unless shown as determined under this section, section 60. General boundary does not determine the exact line of the boundary, and then rules may make provision enabling or requiring the exact line of the boundary of a registered estate to be determined. So that's the basic jurisdiction. And then turning to the rules themselves, the material rules are 118 and 119. And what we find is that under 118, a proprietor of a registered estate may apply to the registrar for the exact line of the boundary to be determined. An application under paragraph 1 must be made in form DB and be accompanied by a plan, or a plan and a verbal description, and some evidence. And obviously, you will know that the sort of evidence will consist of, first of all, any title evidence, that's to say conveyancing evidence, conveyances, transfers, and so forth. And then obviously, if available, some expert evidence, which may just be in the form of a survey showing what's on the ground. But as we know, surveyors tend to go a bit further and opine themselves as to where they think the boundary might be. So if you've got any evidence of that kind, obviously that's the sort of thing you would submit with your initial application. So once the application is in, the registrar, where he's satisfied that the plan and the verbal description identifies the exact line of the boundary, and that the applicant has shown an arguable case that the line of the boundary is in the position shown on the plan, and he can identify all the owners of the land adjoining the boundary, he must then give the owners of the land adjoining the boundary notice of the application and of the effect of paragraph 6 of Rule 119. And what that says is that unless any recipient of the notice objects to the application within the time fixed by the notice, he must complete the application. So in a very simple case where there's no objection, this pretty much goes through on the nod, assuming, of course, as I say, you've got the plan and you've got the evidence to show where the determined boundary should be. Where, on the other hand, the registrar is not satisfied as to those matters in paragraph 1, that's to say the plan identifying the boundary, the arguable case that the boundary is as shown on the plan, and the identity of the owners adjoining the land, he must cancel the application. So you see immediately from the rules that they suggest a fairly binary process, either completion of the application or cancellation of the application, which doesn't leave much room for manoeuvre, obviously, if there is some middle ground, for example. So unsurprisingly, that aspect of the jurisdiction was considered in court in a couple of cases in 2016 and 2018. The first of which was a case called Murdoch and Amesbury, in front of His Honour Judge Dyke, sitting as a judge of the upper tribunal. And he took the view that it was pretty much a binary process. He said, in my judgment, the correct analysis of these provisions is that the scheme intends that the outcome of the application will be completion or cancellation, and not a general determination of boundary issues, which, as we all know at the time and still are conducted elsewhere, principally in the county court. But in another case in 2016, Bean and Katz, Judge Elizabeth Cook put a bit of a gloss on that. And what she said was that there's no doubt in my mind that the first tier tribunal had jurisdiction to examine the title to the land concerned, to decide the success or failure of the determined boundary application on the basis of the decision as to where the boundary lay, and to direct the registrar to give effect to the application. And then this was with reference to one particular part of the boundary in that case, but subject to that specific direction as to the front section. So she introduced here in this case a possible third way, if we can put it like that, where not just completion or cancellation, but the registrar could be directed to come to some slightly blurred decision or effect on the title if that was appropriate. She said something similar well, sorry, before we get to that, she was, the similar thing was said, I should say, by Paul Morgan, again sitting as a judge of the upper tribunal in a case called Lowe and William Davis in 2018, where in that case the appellant's counsel had submitted that initially the FTT had jurisdiction to determine the location of the boundary, but when there was a question as to the accuracy of the plan, the FTT was then constrained to decide that point as a preliminary issue. And having decided that the plan was inaccurate, the FTT lost its jurisdiction. And Paul Morgan said, I don't agree with that. And what he was effectively saying was that, as Elizabeth Cook had said, there is a third way whereby part of the application could be approved and part of it not completed. As I was going on to say, Elizabeth Cook has put a further gloss on all of that more recently in the case of Woodhead and Witt, in which I appeared at the end of last year, when, first of all, early in her judgment, when relating the law and the jurisdiction of the tribunal to deal with these determined boundary applications, she said this. She said, if the FTT regards the boundary sought as partly correct, it may direct the registrar to give effect to it to that extent, but to reject it insofar as it is incorrect. And it may give a direction about the entry to be made with regard to that part of the boundary where the applicant's plan was found wanting. So clearly not quite as binary as originally thought, and certainly as Mark Dyke thought in the first case, which I mentioned. And I think that's possibly why litigants more recently have formed the view that this determined boundary jurisdiction, or this process, may be a convenient way of trying to resolve boundary disputes. Whereas traditionally they might have gone to the county court and possibly with a view to saving money, time and so forth, they think this might be a slightly slimmed down procedure, which might be the way to go. But as we'll see, first of all, in this case, Elizabeth Cook did something slightly different in the end. The position is effectively, therefore, that there may be still, that there's the two binary possibilities, complete the application, cancel the application, but possibly, therefore, the registrar may complete the application in part. But one of the other things that litigants and you as their representatives potentially need to be aware of is that the process is very prescribed in terms of the detail in the determined boundary plan and also the accuracy to which that plan must be prepared. And this is a further consideration which you might take account of when advising clients whether to go down this route. I've stripped this down to the very bare essentials. Those of you that are familiar with Land Registry Practice Guide 40, Supplement 4, Section 4.4.1 will know that there's more to it than this. But this is the important element, it seems to me, because it's crucial to understand the accuracy that's required in these plans before you consider going down the route of a determined boundary application. So we can see that the accuracy must be to plus or minus 10 millimeters, and that's 10 millimeters on the ground. It's not on the paper. It's a minute accuracy that's required, and therefore the slightest problem with either the plan or the plan in relation to where the boundary is going to result potentially in the cancellation of the application. There are other requirements about the taking of the measurements, taken horizontally, and then also taken from at least two defined points on surrounding permanent physical features. Corners of buildings are mentioned there, but if you read on in the the guide, they talk about physical features, certainly things that have been there for at least 10 years. It may be that well-established trees could be considered sufficiently permanent, but certainly not younger trees, bushes, shrubs, and that sort of thing. So it's very important to have that in mind. And as we'll see in the Woodhead and Whip case, that was something that caused a problem as far as the applicant was concerned. So let's have a think about this case, because it provides a useful example as to how the jurisdiction operates and some of the potential pitfalls and the problems with it as far as applicants are concerned. So there were a number of issues in this case. The first was the accuracy of the plan, but in common with many boundary disputes, there were issues as to the construction of the transfer itself. There were covenants in there which had a bearing potentially on where the boundary lay. There was potentially an inferred boundary agreement as well, because over the course of about 20 years, the boundary feature, the fence between these two properties, was replaced on a number of occasions, and obviously not in exactly the same place. So there was a debate about whether there had been acceptance of the new position of the fence as the potential boundary. And then, of course, our old friend adverse possession, which, as we all know, crops up in a substantial number of boundary disputes. So the first marker to put down there is that this was clearly not a straightforward boundary case. I mean, you may think, just pausing at this moment, that the procedure is obviously well suited to cases where either there's no dispute as to the boundary, and one of the parties, for whatever reason, simply wants to have a clear record, a precise record of where the boundary is, for whatever reason. Or, for example, there's been a boundary agreement and the parties want to have that set down in writing, so that, again, it's clearly recorded for the future, because, as we know, oral boundary agreements can be binding on successors in title. You'll be familiar with Sir Robert McGarry's statement in Nielsen and Poole. So that's another good reason why they might want to determine boundary. And there's no question that the jurisdiction works well in those circumstances. But in a case like this, as we'll see, where you've got typical issues that arise in boundary disputes, the question is whether it is really the way to go and the way to advise your clients to go. So here's the the main part, the substantial part of the DB plan in this case. And if I just take you to, if I can, enliven my laser pointer, I'll just take you to the material features on this plan. You'll be aware that there's some quite a lot of verbiage at the bottom, which I haven't included, partly because it was difficult to get it onto this slide. But you'll see that, in fact, and I've slightly chopped it off, I'm afraid, that part of that verbiage is the statement in the bottom left-hand corner that the boundary to be determined runs in a straight line from the corner of the wall at A, which is there, through the centre of the party wall between points B and C. So this is the front of the properties. There are semi-detached. There were semi-detached properties. There's the party wall. There's point C, and ending at point D, which is at the bottom of the gardens down here, which was marked by a concrete post, which it was established was an original concrete post. So these properties, as I say, were semi-detached properties built by George Wimpey Homes in around 1960. But inevitably, in the course of the next 60 years, as we all know from experience, things change. So the original properties came to stretch back from the front. First of all, we've got the street here, front gardens, and there was no issue as to the boundary between A and B. And then we had the, as I say, the boundary, it was agreed, ran through the centre of the party wall, which ran down there, through the chimney breast, which divided the two properties. And the rear of the original properties was in line with this recess here, which you can see, running across the back of both 82 and 84. But what had then happened was that both properties had been extended. So there was an extension which went to about there on number 84, and the 82 extension ended as the rear wall is shown. 84 had then been extended again with the addition of a conservatory here, but you can see that it's stepped back from the boundary. So it didn't form really any part of the debate in this case. So immediately one needs to take on board that the properties have been extended, and of course, however carefully the builders were instructed to and did follow those instructions to construct the extensions perpendicular to the party wall, there's always the room for some slight variation there. But once we get to the rear of the properties, the boundary running down through the rear gardens down to point D was originally a post and wire fence. And the posts were concrete, and as I say, we have the remainder of one of them right at the end of the garden. All the other posts had been taken out, and what was a chain link fence had been replaced by a close boarded fence in large part, and that had been done many years ago, and as I say, replaced over on several occasions. So already, as you can imagine, plenty of scope for movement from the very straight line that was shown on the transfer in 1960. But notwithstanding that, this DB plan, as you can see from the language used down here, purported to show a dead straight line from point A through B through C to D. But there were a couple of, well, as we've already identified, there were a couple of issues in the case which had a bearing on that. And I mentioned the covenants in the transfer. One of them was a covenant on the part of the owner of 84 to maintain the boundary feature, which, as I say, originally was a post and wire fence with concrete posts. And as you will see, I don't know if it's clear from this copy, but it may not be because it's too small, but the applicant's surveyor had drawn the boundary arriving at the middle of point D, which, as I say, was a concrete post. It was said to be 8 centimetres wide. So he had the boundary 4 centimetres inside the 82 face of that concrete post. And had there been any others, you may think those posts as well. So there was immediately a question, as I say, as to whether that was in the right place. And Elizabeth Cook agreed that it wasn't, because she agreed that the true construction of this transfer was that the boundary should be on the 82 face of the concrete posts, because otherwise number 84 would have difficulty maintaining that part of the posts, which was inside number 82. So immediately a 4 centimetre issue at the bottom. And then the other issue was here, where you might just be able to make out the word mortar joint, because where the two extensions had been built, there was a clear and very distinct mortar joint visible on the rear faces of the properties. And whereas the respondent, the appellant, in the end, Mr. Witt, said that the boundary ran through the mortar joint because that was clearly the join of the two extensions, which were built, as it happened, pretty much on the line, or the extended line of the party wall. In fact, the Woodhead said, no, the mortar joint was inside their property, and that the boundary was about 4 centimetres to the 84 side of the mortar joint. Well, again, Elizabeth Cook came to the view that he was wrong about that. Interestingly, the judge at first instance had agreed with him about that, and that's why he succeeded. Well, part of the reason he succeeded at the first tier tribunal, but on appeal and on the re-hearing, Elizabeth Cook wasn't so convinced. She took the view that it was most likely that the mortar joint was on the boundary, and therefore, again, there was a 4 centimetre difference at that point. So, I mean, these are minute differences. As she said in her judgment, it's about half a width of a brick. But that was enough, as far as this jurisdiction is concerned, to call into question whether she should complete, whether she should direct the registrar to complete or cancel the application. but I mean, there was no dispute as to this part of it. That she could have gone down the route that she did in Bean and Katz, for example, and said, well, I'm going to direct the registrar to complete the application so far as the boundary between A and B is concerned, and make some other direction in relation to the rest of it. But in fact, what she did, let me just remove the laser pointer. What she did was to say, I see no purpose in directing the registrar to accept that part of the DB plan that is correct. That's the bit between A and B. Since insofar as it is correct, it is uncontroversial. Accordingly, I direct the registrar to reject the application for a determined boundary. So the outcome of this long saga, where we'd had two trials, one in the FTT and one in the upper tribunal, was that there was no determined boundary. And of course, the poor applicants were ordered to pay the respondents' appellants' costs. And following two trials, you can imagine that they were not inconsiderable. So this all, again, really raises the question as to the appropriateness or otherwise of this jurisdiction for cases which are not straightforward boundary disputes. And I've listed here three key takeaways that I think are important. First of all, obviously the accuracy of the plan, and I've shown you how accurate that has to be. And if there's any risk that your plan is not going to be accurate to that level, then this is a questionable process as far as your case is concerned. Then the suitability of the jurisdiction where you've got legal issues at stake, like construction of documents, adverse possession, inferred boundary agreements, and so forth, and then the likely result. Now, we've seen that certainly Elizabeth Cook and to a certain extent Paul Morgan, who agreed with her, have taken the view that there is scope for a third way, if I can put it like that. But having said that in the opening part of her judgment, then she didn't take it in this case. So that does beg the question as to what extent, when push comes to shove, the judges of the tribunal are going to direct the registrar to give effect to that third way. Whereas you may think that the rules are quite clear. Certainly Mark Dite was of that view, and maybe his view really is the appropriate one, or the one that I think you should bear in mind, because experience like this case tells you that the tribunal might be reluctant to go too much further. So let's have a think about these two jurisdictions, the one that we've just discussed, and obviously the alternative in court. I think I've mentioned that clearly in a straightforward case, it's obviously going to be cheaper to go down the determined boundary route. If you've got a case where there's no real dispute about the boundary, then it's probably the obvious way to go. But obviously, we've seen in this case, in Woodhead and Witt, how, in fact, if there is a dispute, actually the costs incurred are likely to be very similar to those that you'd incur if you went to court. Certainly, again, the tribunal is more informal, and it may be appropriate in a case if, for example, if you're being approached by somebody who may end up being a litigant in person for whatever reason, whether it's financial or otherwise, they decide to do the case themselves, then the tribunal again might be more appropriate because there's a slightly more relaxed approach. People are made to feel more comfortable and so forth. But the thing that you have to bear in mind, of course, and they need to bear in mind about this jurisdiction, is the limited relief available. We've seen that it's pretty binary. And what you aren't going to get, obviously, in the tribunal is an injunction or damages. So if you've got a claim where it looks as though you're going to need either of those remedies, then plainly the tribunal is not going to be the place to go. Or the determined boundary procedure is not going to be the way to kick off at any rate. So as Nicola mentioned, I'm also a mediator and obviously have an interest in seeing whether disputes can be resolved by mediation. So again, thinking about comparisons of the determined boundary jurisdiction with what you might find in mediation, likely to be more expensive, even on the relatively simple route of an uncontested dispute. There are going to be costs involved, and we know that in terms of time, that the tribunal or the land registry, first of all, and then the tribunal have a very relaxed approach to time. So even if you were applying for a relatively straightforward case, trying to get that resolved may take several months, compared with, obviously, we can set up a mediation very quickly to take effect in a week or two or whatever it is. So that's obviously going to be advantageous. But again, I think it's in terms of the possible outcomes where both court and mediation obviously provide so much more in the way of opportunities for litigants to achieve what they really want to achieve. Court is still limited, of course. I mean, there's injunctions, yes, there's damages. But the great thing about mediation, as we all know, or those of us who deal with it more frequently, is the almost unlimited permutations for achieving something that is useful to the clients. You may start out with a simple dispute about where the boundary lies, but then you discover there's all sorts of other things going on. There's leaking water, there's trees overhanging, all sorts of things. And the great thing about mediation, as we all know, is you can incorporate terms into the agreement, which can then be incorporated in a deed of covenant or deed of variation or whatever it is, which provide for all sorts of things, all the things that are really troubling the parties. And as we all know, it's often not the boundary itself which is the issue. That's the legal peg on which the parties seek to hang their dispute, but their dispute is often about something completely different. And again, in mediation, you can get to the bottom of all that and provide help parties to agree terms which will provide a solution to what's really troubling. So just a few final thoughts, if I can get to my slide about that. One more slide, there it is. So yes, just 3 further points on mediation. First of all, you may be aware that a few months ago, Sir Geoffrey Voss, who's now, of course, the Master of the Rolls, gave a talk at Hull University where he majored on mediation. I think he almost went as far as to say that his view is that it should be compulsory. I'm not going to get into that unless someone challenges me about that, but there's a whole talk we could have about that. But what he did say, which is absolutely consistent with my experience and is, I'm sure, with other mediators, is that there's a point in the process, in the dispute, where a mediation is most likely to succeed. And it's the point where the parties have got sufficient information or evidence or whatever it is to understand theirs and the other party's case or position, but they haven't spent so much in terms of costs that the costs become the overriding issue. So in Woodhead and Whip, for example, we did have a mediation, but it happened too late. By the time that we had the mediation, both parties were in for tens of thousands of pounds. And so whereas, they might have come to some arrangement as to where the boundary might be, the costs, I'm afraid, were inevitably, as they often are, the determining factor, and that's why partly the case didn't settle. So it's a question of finding that point and what Sir Geoffrey called the sweet spot. And it's worth thinking about this right at the outset when your client first comes to you, to sort of plan the strategy as to how you're going to seek to resolve the dispute. To think that, well, if we're going to have a mediation, when's it going to be, and when's the best time for it to be to have the optimum chance of success? It's worth bearing in mind, and I'm glad he coined that phrase, the sweet spot, because I think it sums up perfectly the point, which it's the optimum point for mediation. And partly to look for that point, obviously a certain amount of work may need to be done to make the mediation work, whether it's obviously the collation of sufficient evidence as we've identified in a boundary dispute, particularly obviously to have some clue as to where the boundary might be. That might be expert evidence. It might just need a surveyor to draw up a survey of the plot as is and what's on the ground. You don't need them to go further and say where the boundary is. That may be obvious from other points anyway. And then finally, absolutely essential, whether it's a mediation or any property dispute, as far as I'm concerned, I will rarely get involved in one unless and until I've had a site view and seen for myself what's on the ground, because we can all produce wonderful photographs of the site, and they can be very helpful, as can the plans. But there's no substitute for going on the site yourself and having the parties show you, or your client at any rate, show you things that are important to them. Because again, the photographs may not show those, and you may miss them unless they're pointed out to you by somebody else. So there it is. Those are my observations about the determined boundary jurisdiction, having been involved in a case which went to the upper tribunal. Some further thoughts, for what they're worth, about alternative forms of resolving boundary disputes. I can't see, I don't think, how many questions we've got, if any, but I'll first of all try and stop sharing the screen if I can achieve that. And then there we are. If there are any questions, Nicola, this is it.
Okay, we've got one question at the moment from Lewis Glasson, saying the usual rule is that the parties to proceedings in the tribunal bear their own costs. Why was the applicant ordered to pay the respondent's costs here?
Well, that varies actually. In land registration cases, the position is slightly different. Certainly in other property cases, in residential property tribunal cases, that is the rule. But in land registration cases, if you have a look at the rules, you'll see that there is the opportunity for the court to make an inter partes cost order as if you were in court. So this was a land registration case. If you apply for a determined boundary under Section 60 of the Land Registration Act, it's deemed a land registration case. So that part of the rules apply.
Okay. Next question is it worthwhile attaching a joint boundary application to a settlement agreement where you have agreed terms via mediation, or is a transfers preferable, given that you have said what you've said today?
Can you just run that past me again, Nicola? Sorry,
I jumbled my words. So is it worthwhile attaching a joint boundary application to a settlement agreement where you have agreed terms via mediation, or is a transfers preferable, given what you have said today? So whether you go and do the application or not, you could just do the transfer with the settlement agreement.
Yes, you could, but what I'd say about that is that obviously that's the sort of situation which I mentioned, where I think this determined boundary jurisdiction is most effective and most useful. If you've reached an agreement as to where you think the boundary is, whether by mediation or just informally, then one way of recording that would be to apply, if you wanted the precision. I mean, that's the other thing. Obviously, this determined boundary jurisdiction gives you the precision of an exact line as opposed to the general boundary. But if you wanted that precision, then yes, this would be the way to go. And all being well, I'm not making any promises, but in a relatively straightforward case like that, where you've got a clear agreement between the parties, it ought to be fairly straightforward and not involve too much in the way of costs and time.
Patrick Kershaw has a good point here. He says, following a successful mediation, would it be suggested that one party then makes an application to the Land Registry to determine the boundary and the costs are split? So that's where you get that.
Well, again, yeah, I mean, it's a similar point. Yes, I mean, that's another paradigm case for the use of this jurisdiction, this process. You've got an agreement, whether it's one party or both parties. I mean, you've seen from the rules that you only get into the FTT where there's an objection from one party. So under the procedure, remember Rule 118, the application served on the adjoining parties, or in this case, the one party, whoever it is. If they don't object, then the registrar must complete the application. So that there would be no reason why he shouldn't do that if you've got an agreement.
Great. Change of pace from the actual agreement. Here's a different question about expert evidence. I think sometimes we've all been there, whether it's the tribunal or the court, where 24 hours before, say in this situation, a mediation that you've booked several months beforehand, the claimant in the matter produced further expert evidence that the defendant had been unable to digest, which they wanted to rely on in the mediation. How would you deal with that? Do you allow the evidence forward?
Or not? Yes.
Or not?
Well, I think one of the things I said about as one of the positives, if you like, of this procedure is that, as we all know, in the tribunal, it's a bit more informal. The strict rules of court, although they're available, are applied possibly a little more liberally. So my experience is that most FTT judges would allow the evidence in. Obviously, if the other side are prejudiced in any way, that might result in an adjournment, of course. But it would be a question for the judge to analyse whether, and the parties to make submissions about whether that was likely to be the case. But in fact, that happened in the Woodhead and Witt case to an extent, because our expert, in fact, produced a drawing. It was, he said, consistent with evidence that he'd already given, but it was a new piece of evidence in the sense that it was a fresh drawing, which only emerged on the day before the hearing, first FTT hearing. And so there was a question as to whether he should be permitted to refer to it. And in fact, the FTT judge said, yeah, given that it's not actually there's no fresh evidence in the sense that nothing that really takes the other side by surprise, and they had they were given half an hour to have a look at it, and they agreed that they weren't prejudiced by it. It was allowed in. So I think certainly the tribunal takes a slightly more relaxed approach about that sort of thing, and unless, as I say, there was some serious prejudice. And even if there was, I mean, the scope to just give them time to deal with it, even if it's an overnight adjournment, that's always possible. So,
and what about the night before, sort of the mediation? Would you postpone the mediation, or let it go ahead? I guess each case depends on the facts there.
Yes, I mean, as far as a mediation's concerned, I mean, it's not quite like a court hearing. So, I mean, what the parties are trying to achieve is an agreement. It would really be a matter for them if they felt that it was prejudiced. I mean, obviously, mediation is a voluntary process. If somebody turned up on the day with something which took by surprise, they could say, well, actually, we need time to think about this, and we'd like to either postpone the mediation or whatever. The mediator would obviously, I think, be guided by the parties themselves. So it wouldn't necessarily, it's not necessarily going to upset the mediation, because ultimately it might not have a bearing anyway on what they're going to agree. It might go to one issue only, and they manage to agree, come to agreement on others. So it depends on the relevance of it.
And I think this will probably be the last question. We've got a lot of people agreeing boundaries at the moment. So it's another one of that where you've got all reached agreements, we're all friendly as to the location of the boundary. Is there a significant advantage in a determined boundary application over and above a boundary agreement?
Well, the real advantage, I mean, it depends when you say boundary agreement, how it's expressed. But I mean, first of all, as we know, boundary agreements, as long as they're informal and aren't actually resulting in the conveyance of any land, but are merely clarifying where the boundary is on the ground, are deemed binding on parties and their successors in title. If it amounts to a conveyance, then obviously that's a different matter, because if it's oral, then it doesn't comply with Section 2 and is not going to stand up. But if all it is doing is if it's an oral agreement, then again, yeah, I mean the determined boundary process then gives you a very exact record of what you've agreed, and it is, I'd have thought, if that's what you want and that's what you need, I mean, it depends on all those sorts of things, then that'd be the way to go.
Great, thank you very much, Simon. That's really useful, and I think we've all taken pointers away from that on whether we go for the determined boundary or go to the county court. That's the end of any questions. You've been sent Simon's details in the event sign up sheet, but all his profiles on the Radcliffe Chambers website as well. I'm sure you wouldn't mind if anyone approached him afterwards if you had any specific other questions to the subjects. That right, Simon? I've sort of volunteered you now.
Yeah, please make contact. Yeah.
Thank you. So last thing from me, I forgot to say at the beginning that this is being recorded, and the recording of the talk will be available on the PLA website. So please feel free to circulate amongst your colleagues. The next session we've got available or organised is on the 24th of June, and I think an email has just gone out this morning on that for the Southern region are hosting another webinar by Helen Swayfield, who most of you may have already heard of before, because she's done a lot of talks, a lot for the NBL, and in person circuit, doing the usual circuit. Her talk will be on litigating indemnities and exclusion clauses in property contracts. It's very different from this one, but still very interesting, and we look forward to seeing you then. Bye.
Bye-bye.